We've all got our cameras on, and can I just make sure audio is working for both of you?
Yeah, as far as I know, yeah.
Yep.
Can you hear?
I can
Hello?
hear you fine, thank you. Yep.
If you can hear me, raise your hand.
I just want to double check in case it's not something you want to find out at the wrong time.
Sure.
Stuart?
Everything fine for me, I think.
Great, okay, thank you. All right. So, welcome to an online meeting of Kensington and Chelsea's licensing subcommittee. Thank you for attending. This is a reconvened meeting regarding the Roof Garden and Babylon restaurant application, which was held on 8th of February 2024. Our legal officer will shortly set out the focus for discussion at today's meeting. I'm Councillor Toby Benton, and I will be chairing this meeting. I'm accompanied by Councillors Stuart Graham and Doris Schmetterling, the same three councillors who dealt with the previous hearing. This meeting is being held via Microsoft Teams and is also being streamed live. Councillors, can you please introduce yourselves?
Well, I'm Councillor Doris Schmetterling. Yeah, and here, Councillor for Pembridge Ward.
Everyone, Stuart Graham, Councillor for Norland Ward and member of the licensing subcommittee.
While we're doing wards, I'm Councillor for Colville Ward. Okay, thank you very much. And if you wish, you can turn your cameras off. If we have connection problems, you may have to turn them off. Okay. We're joined remotely by Sharon Dybel from the Council's licensing team. Our legal officers, Lindsay Lemazurier, assisted by Heidi Titcombe. Also with us are our committee officers, Holly Weaver, Emily Beard, and Luke Curran. Before we start the hearing for this case, just a few ground rules. Please keep your microphones on mute until you're invited to speak. And please make sure mobile phones are on silent. Do keep your cameras on when not speaking if you wish, unless we run into connection problems, which I think we've just covered preliminary. Please note that the Microsoft Teams chat function is not monitored, so please do not use it. In addition, this is a public meeting and the chat would not be seen in the live stream. Everyone should have received the notification for this meeting regarding the use of cameras and how to connect back if you lose connection. Thank you. At this point,
sorry, can I interrupt? I'm really sorry. Could Mariella or Emma please send my sister the link? Unfortunately, my phone has security settings, so I can't actually send the link to her. So Mariella or Emma, if you could send it to her, please, as soon as possible, that would be great. Thanks.
Who's that?
Yes, sorry, it was one of our residents. I can confirm this has been sent to them.
Okay, I mean, could you maybe have a conversation amongst yourselves on a WhatsApp or something, because it's not going to work to keep interrupting the proceedings like that. Thank you. Okay, so at this point I'll hand over to Ms. Lemazurier, who will briefly explain the purpose of today's hearing. Ms. Lemazurier, please.
Thank you, Chair. Good morning, everybody. The hearing of this application was heard over the best part of the day on the 8th of February. At that time, the committee heard the evidence of the applicants, the responsible authority, supporters and local residents. At the end of that hearing, Councillor Schmetterling asked whether the applicant would consider amending their application so that instead of seeking a permanent licence, they would accept a time-limited licence of 18 or 24 months. As I explained at that hearing, the committee has no power to impose a temporary licence or indeed a temporary condition. Only the applicant can make that decision as to whether they are prepared to offer a temporary licence or condition, because this would mean that once the time-limited licence expired, they would need to start the whole process again and apply for a permanent licence. The applicant's legal advisor needed to take instructions on this proposal and subsequently advised that they were not able to agree to the entire licence being time limited, as they were intending to surrender their existing licence if their application were to be granted by the committee. See Annex A of the document that was circulated to all the parties by governance on the 14th of February. However, the applicant was willing to offer a time-limited condition if their application were to be granted by the committee on a permanent basis. This time-limited condition would mean that the licensable hours on the 6th floor of the premises would be trialled until 3 a.m. on Thursdays to Saturdays, as sought by their application, for a period of 18 months from the date of the surrender of the existing licence, and then would automatically revert to 2 a.m. at the end of that period, unless they applied for a variation to retain the 3 a.m. terminal hour. So in summary, the purpose of today's hearing is firstly to examine the applicant's proposal and to seek the views of environmental health and all the other parties regarding the temporary condition proposal. Secondly, to consider the amended conditions proposed by the applicant, which were circulated as Appendix B to the email dated 14th of February. The amendments relate to conditions 10, 61, 72 and 76, and to introduce a new condition 54A. The committee are also seeking views of all the parties on the above mentioned conditions. I would emphasise that the committee do not want to rehear all the arguments opposing the application made at the previous hearing, as the committee understands the arguments on both sides. As you are all well aware, the applicant has the benefit of the existing premises licence, which is in Annex A of the main committee pack, which already allows them to operate on the 6th floor until 3 a.m. on Mondays to Thursdays and 2 a.m. Friday, Saturday, 11 p.m. Sunday. The committee cannot revoke that licence as part of this application. I would also draw the parties' attention to the comparison chart provided by the applicant in their additional submission, pages 31 to 43, that was circulated on the 5th of February, and also to the comparison pack table prepared by licensing set out in pages 6 to 10 of the main pack. The comparison chart set out what the applicant can do now under the existing licence versus what they are proposing to do under this application. I would urge Mr. Walsh to take the parties through this, comparing what they've already got as to what they are seeking. Thank you.
Thank you very much. Next, we have declarations of interest. Following the previous hearing, members received some emails directly from some of the objectors, and these were passed to the legal officer to deal with. The applicant has confirmed that such emails can be admitted, and they were circulated to the parties on the 22nd and 23rd of February by governance and will be considered. Some of the members also received emails from residents who had not filed a valid representation in time, and therefore these have been rejected. We confirm that we have no other declarations of interest to make regarding this item. The quorum for this committee is 2. As there is always the possibility that I may lose connection temporarily during the broadcast, I'm nominating Councillor Schmetterling to be appointed as the substitute chair. Members, please confirm whether this nomination is seconded. Councillor Graham?
Happy to second.
Thank you very much indeed. I confirm Councillor Schmetterling has been appointed substitute chair. Thank you, colleagues. So for clarity, I will outline the procedure of today's meeting. As explained by our legal officer, I will ask Mr. Stephen Walsh, KC, to explain the applicant's time-limited proposal and the amendments they are seeking to the conditions specified. Then, members will ask Mr. Walsh questions, followed by environmental health and the local residents who are in attendance. I will then invite environmental health to make any submissions they may have on the proposal and the conditions. Questions may then be asked by members, followed by the applicant. Finally, I will invite the registered objectors who are in attendance to make any submissions they may have on the proposal and the conditions. Questions may then be asked by members, followed by the applicant. If there are any matters that require clarification, then our legal officer will notify us. We will then retire to make our decision and will aim to notify the parties in writing within 5 working days. Finally, we will turn to the governance team to see if any issues have been raised that we need to consider. Let's begin. First, the applicant, Mr. Walsh. Please, can you present your submission? And please do have your camera on if you like. You have up to 10 minutes to do so from when you start speaking. Thank you.
Thank you very much indeed, Chair. Look, we are conscious, obviously, of the limited scope of this adjourned hearing, which is why we've sought to summarise the applicant's position in the supplemental proposals document, which I know you have read and which I believe has been sent to all of those who have made representations. The preamble to that document, it might be said to state the obvious, and I know you have it firmly in mind. Any determination on this discrete issue, on these discrete issues, and generally, must have regard to and be balanced against the licensing context in which the application is made, which has just been explained to some extent, and the concessions and the reductions in the scope of the extant license, which have been offered in the application, and you will recall during the hearing on the 8th of February. So in that case, let me just summarise still further, and I confine myself primarily to the question of the powers on the 6th floor. First, the context, terribly important here. This is not an application to create a licensed venue where none existed before. It's an established venue for which licensable activity has been authorised for decades, literally. It is still so authorised under its current licence, which allows the premises to trade with immediate effect until 3 a.m. on Monday to Thursday and 2 a.m. on Friday and Saturday. So it is, and has been, in fact, for many years, within the percentage figure quoted, I think, by others, of premises which trade beyond 2 a.m. in the Royal Borough. But most importantly, really the importance of this element, and which is relevant to the time-limited aspect of the case and the conditions which we've offered, it really can't be overstated, though we are concerned that sometimes it hasn't been given the recognition it deserves. I'm not talking here about the committee. And that is that the extant licence, the current licence for the roof gardens, permits the venue to trade all week, as it did previously, on a basis which so many old-fashioned nightclubs still do and have done. And that is to allow third-party promoters to use the premises for events, to advertise club nights on social media, to be responsible for who attends those events upon payment of a fee, and to be in control of the type of entertainment and so on. To the licence holder, that style of operation presents all sorts of challenges. Lack of control over what is happening in behaviour, customers, and so on. So that's the licensing context. Secondly, how does this application and its new proposed conditions impact on the extant licence? The applicant could have left that element, that is to say, the ability to have promoters of the extant licence remain in place, of course, because it allows much wider flexibility in scope of the style of operation it might operate. But it has not done that because its genuine intentions are to operate significantly differently to those who operated for years previously. And that is the creation of a bona fide members club. Now, the removal of that element of the extant licence, which we invite you to do by these conditions, entirely prevents that from happening again, because you remove the permission. We're not trying to tweak it, we're saying get rid of it. And that will make a huge difference in the reduction of the scope of the licence which is currently in force. Now, in addition, the applicant, as you know, has offered the reduction of the terminal hours on Mondays to Wednesdays to 2 p.m. From 3 o'clock, 2 a.m. from 3 o'clock from the existing licence. And it's also offered numerous other concessions by way of proposed conditions. And it might be just more convenient if you wouldn't mind just looking at paragraph 8 of our supplemental submission, where the key ones are identified there. I don't know whether I need to go through them, perhaps not. You will see paragraph 8A, the permitted terminal on the 6th floor on Monday to Wednesday reduced from 3 a.m. to 2 a.m. The removal of permission to allow public access to the premises, which I've just identified, the introduction of a 7-day buffer, which is wholly exceptional for the purposes of conditions on a licence, at least for admission to membership. SIA patrols of Kensington Square every day, not just at weekends, from 6 p.m. The sound limiter provided now on the sound system when no condition was previously there. No customer access to the path on the southern wall after 9 p.m. and no access to the woodland gardens at all after 11 o'clock. There was no restriction in the previous licence about that. Windows and doors to remain closed after 11 o'clock. There was no requirement in the existing licence for that. And monthly, this is terribly important for reasons I'll just touch on quickly in a moment, monthly rather than quarter meetings with residents, and specifically in the condition proposed to discuss the dispersal and external management plan. And then, of course, membership and booking conditions prohibiting parking in Kensington Square for the purpose of attending premises. Now, all of those elements, we say, have to be balanced against what we accept could be the time-limited condition. And that is, we seek the reinstatement, and put it in that way, of the 3 a.m. terminal hour on Friday and Saturday nights. But even then, that is what we seek. And if you put that in the balance against all of the concessions and reductions that have been offered in relation to this application, but even that element of what we seek by way of greater hours, having considered Councillor Schmetterling's query and request at the end of the last hearing, is on an agreed basis that it can be time limited. And the purpose, of course, is to allow the applicant to demonstrate during that period that its intention to run a well-managed bona fide members club, which promotes the licensing objectives and obviously to the benefit of residential amenity, is a genuine one, and that it works well in practice. And contrary to some suggestions, that doesn't place the onus or any burden of proof at all on the residents to come back to you. It places the onus firmly in the lap of the applicant to come to the licensing authority to vary the terms of that time limited element in 18 months if it has proved itself. So that's the position. And just finally on this element of matters, the applicant KLG knows only too well that the success of its proposal, which involves, as of course we know, the extensive refurbishment of the iconic gardens and the structures within it, depends, it's perfectly obvious having been at the last hearing and today, it absolutely depends on the establishment of continuing and maintenance of close, regular liaison with the local community, including, of course, the residents of Kensington Square. And that is why, it's partly why, at least, so many concessions have been made on proposed conditions, having listened to the legitimate concerns of those residents. And that's also why ongoing discussions will take place. Now, most recently, in fact, there were 2 meetings held last week with residents to carry on discussions. And the intention, as you know, from the conditions which were proposed, is to hardwire that into the licence by the addition of those robust conditions which I've touched upon. It is quite important, actually, just to mention that the discussions have already been, from a practical point of view, beneficial, because they, for example, touched upon concerns about the way in which parking and so on, and the use of vehicles in Kensington Square could be looked at. And our expert, having discussed it with residents in the week, the transport expert, is confident that an existing phone-based number plates scanning app can be modified so as to link to the member of staff and the registration database of members and of those who will be coming on the basis of guests. So all of those things bear fruit, and no doubt it will take time, but we're already very much on it. The only other two conditions I might just touch upon, which have been mentioned, condition 61, which concerns photographic evidence of people who attend. You will see 61 on the schedule. At the moment, it requires that the premises should install and maintain a computer-based identification photographic entry system. Now, our understanding actually was that the photographic element of that condition would be satisfied by providing CCTV at the entrance. And if that isn't the case, you may want to hear either from me.
Mr. Watt, Mr.
Yes.
Watt, I'm just going to say you've come to 10 minutes, so if you
Right.
if you
In
can
that
wrap
case,
up, that would be great. Thank you.
Can I say, if you need to hear about what we were concerned about, then we have people who can discuss that with you in due course. Those are 61 and 72.
Understood. Thank you very
Thank
much,
you.
Mr. Lord. Okay. Excuse me, online always takes slightly longer than I expected to. Okay, so first questions are from the committee. So, colleagues, would anyone like to start with questions?
Thank you, Chair. Mr. Walsh, thank you for your submission. I just wanted to touch on 61. I think I'll probably start with that because it was quite pertinent that you sort of closed your remarks on that point. Would you concede that actually, without the photographic record of those people coming in, you actually don't have a large amount of control over the people in the premises at one time, purely because I'd say a lot of them, if not the majority, will be non-members. By the time you have a member plus a guest, and then you have all the private events, you will actually not be able to identify who those people are. Could you comment on that, please?
Yes, I think the person who's best equipped to answer that direct question, Councillor, is Sue Walter, the Chief Executive Officer. So I can invite her to answer if you wouldn't mind.
Hello, good morning. Thank you for giving me the opportunity to speak. So in terms of our members, all of our members will have...
I'm sorry, Ms. Walter, I'm just going to interrupt really quickly. Is it possible you could, if you have there's a feedback that I'm getting, because I think I'm hearing it bouncing back through your speakers. It's not the worst I've ever heard, but if you can manage that, I'd appreciate it.
Of course. Is that better now? Yeah, that's it. Can you hear me okay now?
Yeah, that's actually better. Thank you.
Okay, great. So what I was saying is that we will have a database of all members, which includes photographs of members. When members arrive on site, they will scan and their photograph will automatically come up on our membership system. In terms of the guests arriving, all guests have to be pre-registered and they go onto our system. So they have to be pre-registered by the member who is bringing the guests into the building. And as we've said at the last hearing, all our members are responsible for the behaviour of their guests. So, of course, if there are any issues with members' guests, it will reflect on the member themselves. But our database has a photograph of every single member.
Thank you. That is helpful. What about specifically the private events? And I mean, I know it's difficult, but could you give a rough number of people you might expect to be there on private events at one time, given that you know the spaces that you might have events in, what the capacity of those is? How many people are we talking?
Yes, it can broadly vary, but the smallest events could be, say, 10 people for a private dining experience. Larger events for members, predominantly for members, will vary between, say, 50 and 60 people per event. And the larger events, which are less frequent, could be, say, between 200 to 300 people. And that would normally be, in terms of guest lists for those larger events, it would be a mix of members and non-members, but we will be operating a pre-registration of all guests, regardless of whether it's for private events or for member events.
I see. Okay, so just to clarify that point, you will pre-register guests for private events as well as the guests for those members that
Correct.
are coming in.
Yes, that's correct. Yes. Yeah.
Thank you, Chair.
Can I just, if the condition were to be amended to that effect, to make so that that's clear, I think I'm not speaking out of turn, that would be perfectly acceptable, just so that that is fully clear.
Thank you, Mr. Walsh.
Yeah, thank you. I think we'll probably come back to that. Councillor Schmetterling, anything?
Yeah, thank you, Chair. I was thinking in terms of the monitoring of the parking and putting a prohibition of parking in Kensington Square into the condition of attendance of the club, of the premises. How would you do this? I mean, you said you'd have sort of wardens, as it were, staff, security staff walking around, but how would you do that? Like every half an hour, every hour? And you said, yes, I mean, there are these phone-based number plate recognition apps. That's true. Well, I can imagine it because there's number plate recognition already around. Yeah, so how often would you, or how would you envision running this parking management scheme?
Yes, Councillor, that of course is something that is in development in relation to precisely how it's operated. But the starting point, of course, is the ability to say to a member, well, you could be a member if you want to, but I'm afraid you've got to sign up to these particular requirements. And one of them is that there should be no parking. So if they do park, that in Kensington Square, for the purpose that this is important of coming to the club, because we can't prohibit people from parking anywhere, save for in relation to the club and membership requirements. Well, then they could be subject to disciplinary, with the possibility that their membership can be revoked. But your question, of course, is, well, how is that monitored? Well, now we've got patrol, we've got SAI patrols now all week, as opposed to just on Friday and Saturday, which is the position under the current license. And during those patrols, they will be armed with information that concerns number plate recognition and so on. Number plate recognition being assisted and informed by the records which are held by the club itself. Now, I'm looking to my left and right because I have people here who have been very much involved in discussions in the course of the last week as to whether we could shed yet further light on that. I'm not sure whether I can beyond that.
You know, how often, for example, would you patrol? And if it's a non-member doing the driving, on part sort of question A, if you like, sub question A, if the non-member's doing the driving,
yeah,
and sub question 2B is what if it's an RBKC resident who has a permit and obviously is entitled to park?
Well, that is a tricky one, of course, but which we discussed on the 8th, did we not?
Mm.
But there is a difference, is there not, between forbidding someone from parking in Kensington Square, particularly someone who has a permit. We can't do that. Nobody could do that and say you're forbidden from parking in a particular place. But for the purposes of attending the club, even though there is a permit, then it's perfectly proper to put that into a requirement. Now, I wonder, however, I know I also have sitting to my left-hand side, Kiri Spari, who is the project lead who gave some evidence to you last week. He's very much directly involved in how this operates. Can I just pass over to him, Mr. Spari, please?
Good morning, everyone. I think the first keynote here is, to an extent, we need to park who on a day-to-day basis is allowed and not allowed to park in the square. The simple fact is, if you're a member of this club, you are not, under our rules, allowed to park in the square. And that is our starting point. Of course, there will be members that have relevant residence parking permits that may allow them to park in the square. But for the purpose of visiting this club, that member, regardless of their existing permit, unless they happen to live in the square, would not under our rules be permitted. The issue of, well, if it's a non-member driving, etc., that's all largely an irrelevancy that we will need to get into the detail as we develop our own membership rules. If you're attending this club as a member or a non-member, probably unless you're a blue badge holder or you live in the square, you are not allowed to park in the square. That's point one. Point two is, how do we then enforce this? We need to do more work on this. However, there are a large number of systems on the market that are either directly relevant or can be amended for our use, whereby recording car registration details on our membership forms, we can, through phone technology, monitor with our SIAs very quickly which cars in the square may belong to members. That's a technology. Similarly, if the residents want to participate and provide registration details of cars in the square belonging to residents, we can also track it in reverse, so to speak, so we know a car belongs to a resident or belongs to a member. Third point, and probably a very significant point, with the number of SIAs we are proposing from 6 o'clock, constantly patrolling or stationed at our door, the entrance to the square, or patrolling the square, it is not difficult to spot somebody parking in the square and walking over towards the building. It's a short distance. I think through technology and through vigilance, we can develop a system that will, in the majority of time, preclude people parking in the square.
Thank you. But I was just wondering, in terms of frequency, you said frequent, but like every half an hour, every quarter of an hour, walking around the square?
Well,
every hour, I don't know, just what's your opinion?
The SIAs have to patrol from 6 o'clock. That's what's currently offered. So I would have thought from 6 o'clock onwards, we are carrying out that service.
But yeah, I understand that. Sorry to press about this, but you haven't said what potential frequency this could be. They could patrol every 2 hours. They're still patrolling regularly. But the question is, what roughly what do you have in mind, just as an idea?
It's a constant patrol from 6 o'clock.
Walking around all the time, walking around the square all the time.
The current condition, excuse me, we're just muting Stephen's laptop. The current condition requires us to patrol the square constantly. I think from 10:30, this is the existing license, 10:30 until 30 minutes past close. And it literally means patrol constantly walking around the square. I think what we have now offered is from 6 o'clock onwards, we will constantly walk and patrol the square.
Right.
And as part of that responsibility, the SIAs will be trained for what training is required to also check registration numbers.
Okay, thank you.
Okay, now, if there are no further questions from my colleagues, I am aware, sort of before we get to the next couple of questions, and because of the nature of this hearing, we're actually requesting amendments, and typically we do, you know, require 10 minutes. But since I did sort of cut off Mr. Walsh in mid-flow, and we do kind of really want to be very clear about these amendments, I think I should actually ask if you wouldn't mind, Mr. Walsh, if there's any further clarity you'd like to offer on those amendments before we go to the next round of questions. Is that something you could do or would like to do?
Thank you, Chair. I think the only other element that I want to go to now, because I was about to, other than 61, which we've just discussed, is that presently condition 72 has an element on it which is rather unusual. It might be intended to apply to shadow licenses, I don't know, but the latter part of it, you see the last sentence of 72 says The license has no effect if it lapses or has been surrendered and is incapable of being resurrected if the lease of the premise has been subject to forfeiture. It's that final element of it that we dispute as unusual. What we're suggesting, and Mr. Thomas is helping me with this as I speak, is that condition should read: this premises license shall have no effect until such time as the existing license for the 6th to 8th floor, 99 Kensington High Street, premises license number, etc., has been surrendered and is capable of being incapable of being resurrected. So simply remove the word lapses and leave it as has been surrendered, which we think is the neater way to do it and doesn't involve complex issues of forfeiture and that sort of thing.
Can I interject, please, Chair?
Absolutely, yes, and thank you, Mr. Walsh. Yes, please. Liz.
Yes, sorry, Mr. Walsh. Sorry, I did not mean to interrupt you. I just wanted some clarity because obviously your client has got a lease of the premises from the landlord, have they not?
Yes.
So there is a lease in existence. So
yes.
Obviously, in relation to condition 672, can you explain why would you not want the word lapses, or if the lease has been subject to forfeiture proceedings? I mean, surely that would be more of a safeguard to the council. Can you explain exactly why you wouldn't want those words in?
Yeah, well, first of all, it would be an unusual condition, and one could well see why it shouldn't be there. It should be there for shadow licenses and so on, for obvious reasons. But I mean, one of the concerns is when it refers to forfeiture proceedings. I mean, there's a difference between something being subject to forfeiture proceedings and actually being forfeit as a result of forfeiture proceedings. So it's one of the reasons is that it lacks precision, I suppose, because when is something subject to forfeiture proceedings or not? Is it where it's been forfeit or not? And we just say it's not a necessary element of a condition of this kind, which the purpose of it, of course, being to ensure that the new license does not operate, if it is granted, until the existing is surrendered, which
so are you saying you would be happy to include that wording if the lease has been fully forfeit? Is your concern about during forfeiture proceedings?
Well, it's
having completed.
Yes, it's certainly in relation to forfeiture proceedings, yes. But even where it says where the license is forfeit, it seems to us not to be a necessary condition. But we're not for a moment anticipating any such event occurring. And you may think that we're being overly legalistic about it, but we genuinely don't feel that it's a necessary condition. I have Mr. Thomas, who feels quite strongly about this, who may want to speak about it himself.
Well, Chair, it's only that condition would then survive the surrender condition. So as Mr. Walsh has said, the purpose of the condition really is to make sure that the extant and existing public nightclub use is surrendered in favour of the new licence being granted. If you adopted the sort of wording that's been proposed by legal and not by the interested parties, I believe, then that condition would potentially survive and continue even after the existing licence has been surrendered. And I don't think that was the original intention of the discussion regarding the surrender. So the surrender is one thing, but having a condition that would then survive and continue is another, if that's this. Do you agree?
Yes, I think that's put it in a nutshell. I don't think we can expand upon it any further. And that's where we stand.
So turning to in Annex A, your response and your proposed condition and informative, I just wanted to clarify some wording. So yes. Your proposed condition is the terminal hour for all licensable activities on the 6th floor until 3 a.m. shall revert to 2 a.m. on and from the date that is 18 months. And you've put after, and I'm suggesting that the word should be from the date the premises license is surrendered. Do you have any comments on that?
I can well see why you prefer from rather than after. And I'm looking to my left, right, and all over the place. No, we have no problem with that word being substituted, and could see why you would want to do that.
Okay, that's good. Sorry, I will hand back to the chair for the councillors to finish their questions, and then obviously if the chair could pass back to me afterwards, because I just wanted to jump in at that particular point. So
Sure.
Chair, back to you, and then back to me afterwards, if that's okay with you.
Thank you.
Thank you, Ms. Walsh. Thank you, Lindsay. And you must forgive me, this is just a tech thing which just takes me slightly longer to find my place. Okay. Yep, no, as Lindsay said, this is now time for questions from our legal officer, Lindsay. Please go ahead.
Back to me then, sorry. Okay, so we've discussed the temporary condition. I just wanted to focus on the conditions in Annex B, which you raised following the hearing. So can we turn to condition 10, please, where you're offering 7 days rather than, sorry, just bear with me while I find my bit of paper.
Yes.
7 days membership instead of, I think it was 24, then it went to 48.
Yes. So to be clear, we're now saying no person should be admitted to membership of the Said Club without an interval of at least 7 days between nomination or application for membership and admission.
Okay, fine. Okay, so I'll quickly run through these, and then obviously then there'll be questions from the other parties as well, and then there may be further questions from me. Obviously, you're introducing a new 54A about first aiders being present on the premises.
Yes.
We've discussed condition 61 about the photograph. We can discuss condition 72. Condition 76, no customer shall be admitted to the premises later than 1 hour before the terminal hour for the sale of alcohol. You've offered condition 76 on the basis of the hours you're seeking. If members were minded to reduce hours, would that condition not apply, or would you be willing to still have that condition on the licence?
I'm just taking instructions. I can't see that. May I come back to you on that?
Yes. Yes, of course. I think I'd also just like, the purpose of this hearing is obviously to focus on the issues raised in Annex A and Annex B.
Yeah.
But can I just double check a few other points, just for the sake of clarity? Private functions, they aren't necessarily just going to be on the 7th floor, they could be anywhere in the premises. Can you confirm that? Like they could be in the gardens, for example.
Yes, they could. Yes, they could.
Okay. And when you're having a private function, can you just confirm for me, I accept that sometimes guests and members can be present at the private functions, but will there ever be a private function whereby it can be guests only, like non-members completely?
Yes, oh,
that's possible.
Yes.
Thank you.
Yes, yeah.
And in terms of the dispersal and external management plan, it was touched on at the last hearing, and I think Mr. Mahaffey, the licensing officer, also referred to this. The committee might be interested in adding wording whereby the Residents Association are also consulted on the plan, and that environmental health would sign off the plan. So I just wanted to confirm that we had that discussion and your views on that.
Yes. Yes. So yes. So can I just make this very plain? The whole purpose of the monthly meetings with residents is to consult with them and to consult with them meaningfully. And that includes in relation to the dispersal plan. So we have no problem about there being a requirement that there should be consultation with the residents.
Are you talking about just via the monthly meeting? I'm talking specifically here in relation to condition 36. If the committee obviously were minded to grant this application, I'm thinking of wording being inserted, and it was talked about at the previous hearing, about the Residents Association being one of the parties consulted on the plan, and environmental health to sign off the plan. Are you able to that?
Yes.
Thank you.
Well, and it's for environmental health to sign off the plan, obviously.
Yes, not
As a
the Residents
responsible-
Association.
Yes,
Residents
yes.
Association would have input and be consulted on.
Yeah, consultation with the environmental health signing it off. I mean, yes.
Fine, okay, I just wanted to clarify that. And one last clarification, there may be others as the committee unfolds, but I just wanted to clarify existing or proposed condition 62, where you talk about ESMEs and the 6th and 7th floor terraces having wait-to-waitress service.
Yes.
Is that to be to seated customers? I know you don't want a restaurant condition, but is that to be seated customers?
Well, it might be, but not at all times. I mean, when one thinks, for example, of ESMEs, it could be a canapé function with canapés being served and with drinks, champagne, and so on being served in the ordinary style, and the same kind of flexibility would be required elsewhere on the 7th floor terrace as well.
Okay, so yeah, you perfectly noted the word seated. Okay, fine. Okay, I just wanted to get clarity on that point. Okay, I think they're the questions that I just wanted to ask at this moment in time. So I'll hand back to the chair to open the questions to environmental health and the residents, and then we can all I can interject later on if that's okay. Thank you.
Thank you, Lindsay. Okay, yeah, so next questions will be asked by the responsible authority, and I'm looking for Keith, where...
Right. Good morning.
Sorry, I was just looking for you on the list, and I can't find you, but I can hear you. Okay, thank you. Please go on.
Would you accept that any form of noise that generates in Kensington Square is very much a reactive situation, and basically something that you have to deal with on a reactive basis rather than on a proactive basis?
No, don't agree with that at all. There was a difference between having a mechanism in place by which you just react to problems as they occur, by contrast with a range of measures which are designed to eradicate or to reduce the likelihood of them. Our position about this is that patrolling is as much about deterrent as it is about stopping people from doing things. Number plate recognition, other membership requirements, all of those taken together, I'm not listing all of them, but all of them together are a suite of measures which are designed not just to be reactive, but to anticipate problems and to prevent them from occurring in the first place.
Would you also accept that not all proactive measures that you're proposing will stop the noise that residents experience from the premises, and as a result, the disturbance that they do experience that does occur will still be extremely disturbing to them?
No, absolutely not. I'm going to go back here. I think that's far too robust an approach to adopt, because what it doesn't accept is that these are premises that have been licensed for a very long time. They've gone through different forms of operation. Now, if the position were that these premises were to do what Virgin did, and on Friday and Saturday nights had 600 people in the premises on a promoted event on payment of £15 or whatever it is, with massive queues outside, and then people all turning out at the same time at 3 a.m., there being no proper control over them, as the committee found at the review hearing in 2016, well, then I would agree with you, Mr. Mahaffey, and I historically have always respected your view on many things, as you well know. But I think to equate that position to what is proposed by this applicant for a private members club, with a whole range of suite of measures that we've been talking about, is not something which would properly lead to an inevitable conclusion that there is going to be significant disturbance to residents, because you couple in all sorts of measures which we've factored into the operation of the premises. And the applicant's position is that these premises can be traded in such a way as not to cause disturbance to residents of Kensington Square. Not forgetting, of course, that the committee in 2016 found that, of course, there are other uses in Kensington. There are other people in Kensington, people coming and going from elsewhere. And one can't, this is the committee's words, not mine. You can't always pin every single situation and every noise in every instance to the operation of the Kensington Roof Gardens. Anyway,
Okay.
That's a bit of a long-winded answer.
That's right. Thank you very much, Mr. Walsh. Just another question too. It's really to do with the differences between a 2 a.m. and a midnight. Would you not accept that residents being woken up at 2 a.m. in the morning by people in the square is going to have a greater effect than residents being woken up at midnight by people in the square?
Well, the answer to that is I wouldn't want residents being woken up at midnight or at 2 a.m. By customers coming from the Kensington Roof Gardens. And if the situation were to be that there was disturbance, noise and difficulties at 2 a.m., well, of course, that would probably be more annoying and more inappropriate than midnight. But our whole position here is that by working with residents, by adopting the suite of measures to deter and control people, that can be prevented and brought within a proper ambit, such as to be able to say that the prevention of nuisance licensing objective is positively promoted. That's what's the intention of all of this.
Thank you very much.
And the final bit of it is, of course, one can't ignore the extant license, which is how the premises can trade immediately, which requires SIA only at weekends and later hours and so on and so forth. But anyway, perhaps I'm labouring that point too.
Thank you very much. I believe my colleague, Councillor Schmetterling, has a little follow-up.
Yeah, thank you, Mr. Walsh. I think the question was answered, but just to double check, also guests will be part of the computer-based system of identification and so on. Is that? Did you understand that correctly? Did Ms. Walter say that, or did you say that? You're on mute.
Ms. Walter said it. It's pre-registered guests, so people have to be pre-registered.
So if somebody walks in without a name, if a member walks in accompanied by someone whose name is not on the list, they can't come in.
They would have to be registered before they could come in. So someone could bring a guest, but they would have to be registered before they were allowed in.
So registered on the door?
Yes, with photographs and so on.
Right. So let's say they don't have a photo ID with them.
Well, they would have their, I don't want to be facetious, that a photograph could be taken.
Oh, you mean take a photo? Yes, sure. Sorry about that. I didn't think of that.
Was nearly
immediately. But then let's say they drove the member in and parked in Kensington Square. They'd be found out, let's say, half an hour later, and then they'd be turfed out or requested to move the car.
They would certainly be requested to move the car. Yeah, if that was the position. And in any event, I'm hearing from the chief executive in my right here, Ms. Walter, that would expect it to be spotted by the SIA patrol. But of course, it's about an ethos of the members club. All of the members, whether they're bringing a guest in or not, know what the rules are, and there's intended to be a buy-in to it. I mean, we can't control everybody to every nano aspect. We can't micromanage everybody. But one of the key aspects of this whole scheme is that people are buying into a membership approach where they understand what the rules are.
Thank you.
Okay, thank you very much, Mr. Walsh. So finally, we have questions from objectors. And I see first hand I've seen going up is Ms. Cowley. Please go ahead.
I'm not sure that I've unmuted. Have I succeeded?
We can hear you, yeah. We can hear you. Thank you very much.
I have two questions, if I may. The first one concerns data protection. I assume that if this patrolling and number registration is to work, the patrol must record every single registration in the square. A lot of those will not be recognised because they're not the cars of members. What happens to that data?
I'm just, that's a really good question, actually. We don't record the data. So it's not being, so under the Data Protection Act, if the data was being recorded and stored, we'd need to have a justification for it. And we'd need to have a system by which it was to be deleted. But my understanding of the position, yes. So we're not recording the data, we're comparing it back to our membership information. So in other words, if you go, if you go into St. Neots, I do this quite a bit, then there's your number plate pops up straight away. And there's a question about whether they should be retaining, but that's not the kind of thing that happens here. The purpose of the number plate recognition app, the software, is simply to identify members' registration numbers. And so it's a very good question, but they are not retained at all.
Thank you. My second question, we've heard a lot about alcohol, etc. The type of person who will be a member of your club, creative and entrepreneurial, etc., are noted for quite high consumption of recreational drugs, cocaine being the drug of choice. What plans do you have for drug sweeping, identification of drug use, etc.? Because as far as I'm aware, that has not been addressed at all.
Obviously, in any venue of this kind or any other, people ought to be alert to the usage of controlled drugs, because it's just what has to happen. I'm speaking without taking instructions, but I am assuming, and I will get that confirmed, that members of staff are trained not only in licensing laws, but also in those which deal with alcohol consumption. They're trained in relation to that, how to recognise it, and they will certainly be trained for the purposes of the recognition of the use of controlled drugs. And I'm looking to both sides, and I'm having that confirmed.
Zero tolerance.
Zero tolerance is what I'm.
And it's in the incident log. You have to keep a log of any of the drugs.
That's true, yes. And I'm also reminded that the condition which requires that we keep an incident log requires us to record and keep incidents, including controlled drugs information.
May I therefore suggest a slight amendment to the assorted conditions, and I do not recall which number it is, where you speak about staff receiving training in alcohol abuse, that drug abuse be included there. I have no idea what would be the appropriate legal wording, but I think it's important that everyone sees that this is being taken seriously.
Yes, the answer to that is yes. We just have to think about some wording for a moment, but it's a fair point. It's a good point that's made, and yes, we would do that.
Thank you. I'm finished, Chair. Thank you.
Thank you very much. And just for my own keeping track of these, could you put your hand down on Teams? Thank you. Okay, next, Mr. Sterling, I see you have your hand up. Please present your question.
Yeah, I had a few questions on the conditions, please, and maybe just to sort of start on traffic management condition 15. Given the Derry Street can be congested during the day, and it's a cul-de-sac, how are you going to control? What measures or conditions can you put in to control people driving into Derry Street, including taxis, cars, and dropping off. I think when we had a meeting with the applicants team this week, they suggested potentially including geofencing to stop Ubers going down Derry Street, and potentially having 1 or 2 car jockeys or marshals to stop people driving down at night time, because otherwise you're just going to have a constant queue of cars that are going to be doing U-turns at the intersection with Kensington Square.
Yes, you're quite right. That was a part of the discussion, as I understood it earlier in the week, and that is to say the use of geofencing and other measures. And the answer to that is yes, that certainly is the intention, and it may be that the form of words can be drafted for that. I don't know if
it also prevents an operational plan that we have to consult.
Yes, and the point is made that by Mrs. Byron, that would be part of the operational plan upon which we would need and would be required to consult with you and with the residents about it.
So you have to put that in as a condition, along with the traffic marshal being there every evening to prevent people from driving down there.
Yeah, well, yes, I'm right. I'm told to say yes to that. I was going to say something, okay. but the chief executive, Ms. Walter, has robustly said yes to that.
Okay. The next one is on condition 16, parking in the square. So I did sit on the board of APCOA, which is Europe's largest car parking and parking enforcement company, for many years, and spoke to the chief executive there this week about this, and their view was that this was unenforceable, primarily because your plan was unenforceable because DVLA is not allowed to disclose people's number plate details unless they have a parking ticket, and you're not going to know how many cars people have, or whether their guests have cars. So again, I want to come back to this point. Having people walking around the square, sounds good, but this is unenforceable. So
sorry, what is unenforceable? What element of 16 is unenforceable?
How are you going to, if a member has more than one car, how are you going to force disclosure of all of the cars they own? How are you going to get details of car registrations of guests, and how, or people, the 300 or so people who may be having a private event in the club, how are you going to get details of their number plates?
Okay. The condition at the moment is that it will be a condition of membership, and this is the condition 16 that you're talking about, and any private booking that patrons and their guests must not park in Kensington Square or adjacent streets for the purpose of attending the premises. That's the condition. Now, I think what you're anticipating is that members will simply flout it, and how can we enforce against them? We don't anticipate that members are going to just ignore it and flout the requirement in there. But for the purposes of conditioning license.
Well, how are you going to monitor it? Whether they are or whether they're not flouting it.
Just a second, if you would you like to deal with this or not? Okay. Well, I'm going to invite Sue Walter to deal with it first. There are many things I could say about it, but sometimes I think it's best for the representatives of the applicant to be able to explain to you how things work in practice. So, Ms. Walter.
Thank you. Hello, Alex. Sorry, we're just making sure there's no echo. Have you muted? Stephen, can you mute, please? Yeah. Okay, thank you.
Sounds fine here.
Okay, great, thank you. Yeah, so you're absolutely right, Alex. This is going to be one of the more challenging aspects of the traffic management policy to police, but it doesn't mean that we don't put every effort into preventing people from being able to circumvent the system. And from my perspective, it really is about a combination of the vigilance of the SIAs, particularly the ones who are going to be placed in the square, by the square. As you know, there is not that much of a distance between the entrance to the square and the entrance to the club. It'll be obvious if anyone parks in the square, gets out of their car, goes into the building, that they are coming into the club, particularly if they then come in and then register and go upstairs. So it's going to be very simple for people to be able to actually monitor it in person. The second aspect of it, as we've already said, is the use of technology. What we're not proposing to do is one or the other. What we're proposing to do is both. And in terms of really fleshing out the traffic management policy, what I would very much expect to do, as was mentioned just now by Stephen, is to consult with the residents, yourself included, Alex, because it's clear that you have a lot of experience in this space as well, about other measures that we could be doing. This is going to be an evolving process. It's going to be something that we work together on. And what you have from us is a sincere commitment that we will do everything we can to prevent these kind of incidents from happening. But in terms of members' guests, if they're driving in, they're going to be firstly discouraged from driving in. They're going to be sent a list, all members will be sent a list of alternative areas to park within Kensington and Chelsea to avoid the square. It's part of our member rules, it's part of our event rules. We're not just telling people not to park in a space, we're telling them where they should park. The geo-fencing, we've already spoken about that we will do that. We've also talked about traffic management, of having traffic jockeys out there, out on the streets, as well as the SIAs, and the SIAs also being trained in that. The SIAs will also have body cams, which has been previously mentioned as well. So, you know, obviously I can't say that there will never, ever be a breach, but what I can say is that we will do everything we can to prevent that, and we will work with the residents to continue to refine and develop the policy to make sure that it's working for everyone.
Should the detail there be specified and agreed before this license is granted? Because I think what you're saying is best efforts, we'll try. Which is not ideal, I have to say.
Okay, is there any more?
I thought I was dealing with an echo there. No, we wouldn't be prepared to do that, but because the whole purpose of the ongoing consultation monthly meetings is to consult in relation to the management plan. It's an organic document. But we, in relation to that kind of, I could say micromanagement issue, we wouldn't be prepared for that in some way to be a condition precedent before the premises could open.
Okay, okay. Well, the devil is in the details, Stephen. But anyway, I want to go to quickly a couple more very briefly, Toby, if you don't mind. Condition 41. We discussed having an exit via the fire escape on Kensington High Street. My understanding is that you've asked, but I still think this is something that could be explored, and I do want to put it on the agenda that we would want to sort of explore this further with the landlord, who I don't think is black and white about saying no to this. So I would like to come back to this if possible.
Well,
I don't know if that can be reflected in the condition.
Okay. Yes, in relation to that, there, as you know, as a result of the meetings of the week, the landlord has been approached again. And the long and the short of it is that the landlord has said that that would not be a viable or appropriate exit. But as
I know, because I spoke to the team and they said it's not. If you're asking the question,
is now the applicant closed the door, as it were, to that element? The answer is no. It's not closed. The door isn't closed, and that there will be further discussion insofar as it's possible to have it. But you will be aware of the issues that arise in relation to that as a potential exit.
Yes.
But no, the door is not closed to it. There will be continuing discussions about it.
So we should, I think on this, I think we should, because the freeholders confirmed to me that they would be willing to have further discussions on this. So I think we should jointly do that, explore that avenue, even though I know it's not your preference. And in the meantime, I wonder whether you would consider on this condition 41 having a sort of more clarity to say that marshals will be instructing guests to leave towards Kensington High Street when they leave the club in the evening. Because at the moment, the word it says the exit. It says the exit nearest to Kensington High Street.
That is something which is certainly in relation to the operation of the premises on the ground floor, without a doubt, something which the club intends to be doing. And just to get this clear, you're saying that it would be useful to have that as part of condition 41. The applicant will see the premises, yes.
Marshals will instruct guests to make their way towards Kensington High Street.
Yes, yes. Funny enough, I thought we already had something like that in there. Yes, there we are. Condition 41, forgive me, and it's been pointed out to me. Yes, I'm minded to say yes to that. Instructed the SIA should instruct people to leave towards. Yes. Yeah.
Okay, and then I think on the rubbish collection and deliveries, conditions 44, 49, and 68. In the past, there's been serious noise issues from deliveries at night time, rubbish compaction, broken glass, etc. And so I think for these three conditions, would you consider having a blackout period from 9 p.m. till 7 a.m. for no deliveries, no rubbish collection or compaction to make sure that there isn't additional disturbance?
I'm just taking instructions off on that. If you don't, I'll be back to you in just a second, Chair, if you would allow me a minute.
Okay. There.
Yes, so the position in relation, I think, as you know, is that the loading bay down there is used not only by the roof gardens, but by a number of other users. And there is, I think you may know this, in place an agreed protocol with the landlord and to which all other users of the loading bay and building have got to buy into, which of course includes the Kensington Roof Gardens. It's difficult to put into a direct binary black and white condition here, but the intention is to that which you seek by way of those conditions, if it were possible to do, is very much something that Kensington Roof Gardens would want to do, but can't really commit to a black and white condition about it. It's about the management plan, and it would be part of the management plan itself.
But Stephen, none of the other tenants in the building have deliveries or rubbish collections or compaction at night time. They typically happen in the morning or in the daytime. So I think what we're looking for is some wording here which says that you will not have deliveries at night time. Let's say square brackets 9 p.m. till 7 a.m. and you will not have rubbish collection during that period as well.
We don't have independent rubbish collection, so if we acknowledge this,
we are certainly. I mean, otherwise we could get into quite a big debate about this. Because, for example, we don't have independent rubbish collection, so the rubbish is collected in relation to the whole of the building, so we wouldn't have full control of that. But there are other matters as well. This is exactly the kind of constructive, because we see your point and would want to be able to satisfy all of the concerns you've got, but we absolutely see it. But it would be very difficult for us to suggest or be able to put forward at this stage a condition, because we need to discuss with you and with the landlord broader issues of rubbish collection.
Why don't you have some wording which says the operating principles will include restriction on rubbish collection, rubbish compaction and deliveries during this period.
Yeah.
Okay, I'd like to.
I wasn't sure if I followed that, but it part of the operating plan. Sorry,
sorry, Mr. Walsh, if you don't mind me interjecting. I mean, this isn't something we can't condition things which the applicants can't control. But this is something that could be discussed at residents' meetings. But I think we're reaching the sort of limits of our actual remit here. And I really, I do appreciate that we have some, genuine expertise and genuine concerns. But if you don't mind, we can move on to another question. Alex, is that all right?
I think that's broadly it. The queuing, there's a bit of ambiguity around the queuing outside the club. I can't remember which condition, whether it's condition 36 or one of the others. But will there be queuing out on the street or not? And can we have it as a condition that there won't be queuing? It's not 36. It's 40.
Just have it.
Condition 42.
The door supervisor shall maintain an orderly queue inside and not outside the premises.
Yes.
But that can be read to mean they must make sure it's a disorderly queue outside the premises. So it ought perhaps to be tweaked. Look, here's the position. The nature and style of the operation, by contrast with the promoter situation previously, which involved big queues, will not involve the use of queues. But one can't always completely, in all circumstances, assume it's a.
Stephen, why don't you just include there will not be queuing outside? That's all we're asking for.
Yes, store supervisor should maintain orderly queuing inside and not outside the premises. Should ensure that there is no obstruction to the highway. That's fine. Yeah. Okay.
No further questions.
Thank you very much. Okay, so the only other hand up so far I've seen from objectors is excuse me one moment. Now, because of this layout, is
Chikogliani's put her hand up.
Chikogliani, that's exactly what I was looking for. I'll fess up. I was the display. I can't get her whole name to display, so I was just trying to get that up, and I apologize. So yes, please, Mr. Chikogliani, could you ask your question now?
Thank you very much, Chairman, for allowing me to ask the question. Just a quick question to the applicant. I'm still not really clear how you monitor the customers from the club late at night to actually go and pick up an Uber or a taxi from the southern corner of Kensington Square. So, and the reason is that I'm sure that your security guards can monitor the entry into the square in the corner of Kensington and Derry Street, but then coming from, Uber sitting on Young Street or Thackeray Street, I think is quite difficult. So, and especially when in the late hours you have customer coming out in double digits and you have single digit security guards, I find this very hard to, I just would like to know how you plan to actually monitor that and avoid that they come.
Yes, I think that's probably a good idea of the chief executive officers who Walter answered that question. So I'll pass it across to her.
Hello. Sorry, can you just?
I'm not as nimble as.
Thank you. So we're very confident that the SIAs, particularly the extra number of SIAs that we're laying on, can monitor that situation. In addition, as I mentioned earlier, we're also going to be supporting the SIAs with technology, which includes geofencing of the location, which means that people leaving the club cannot book Ubers from outside the front of the building. They will have to go down to Kensington High Street to book their Ubers.
Okay.
And you plan to ask also guests or participants to, public event or private event to actually do this? Again, the technology I do not know, so I do not know how possible it is or not.
Yeah.
It's just that at 3 a.m. in the morning or later, because if you close at 2 a.m., a customer will probably go home at 2:30. So we'll be still on the street between 2:30, 2:15 and 2:30, because finding a taxi at that hours is not always very easy. So
I understand, yeah.
3 o'clock becomes 3:30, 4 o'clock. So, and again, if you block them next to the corner of Derry Street and Kensington Square, in any case, the entrance to Kensington Square comes from Young Street and from Thackeray Street, not from Derry Street.
Understood. So just to confirm that the geofencing applies for everyone leaving the building, regarding whether they're a member or a guest. So they will not be able to pin their Uber to collect them outside of the building. In addition, we're very confident that the SIAs will be managing people as they leave the building and conducting them down to Kensington High Street, where they can pick up a black taxi cab or they can order their Uber from there. And the other question that you had was really around if the club closes at 2, people will be hanging around at 2:30. Our plan is that we will commence egress an hour before the club is due to close. So if the club closes at 2 a.m., we commence egress at 1 o'clock, so that we're phasing that egress. So by the time we get to 2 o'clock, the club is empty.
Okay. Are there any follow-ups?
Okay, thank you.
Lovely, thank you very much. And we have one more question from an objector. As far as I can see, Ms. Picciotti, please ask your question.
Hi there. Good morning, everyone. Thank you. This is a question on behalf of KSRA. The first one is, I have a few questions. The first one is from Mr. Walsh. You mentioned a lot the previous license. I just want to make sure that, do you agree that the previous license, irrespective of what it permitted, was not operated more than 2 days a week compared to the 6 days a week that you are proposing?
No, I don't actually entirely, except that in the course of the 2016 review, you will recall that there was evidence of its use earlier in the week, as well as weekends. And it may not have been operating late into the night earlier in the week, but there was certainly a history of the club having been used during the week and not just on Fridays and Saturdays. As to the precise extent to which it was used, I suppose that will require all sorts of evidence, but our short position, as we understand, it was used.
Even we're talking about post-midnight use. The club was not used post-midnight, and this is why we ended up with a license that is later during the week. And if you go through the committee minutes, you will see that the committee reduced the weekend hours because it was only open post-midnight on Friday and Saturday. Do you not agree with that?
Yes, I do agree that the committee did not reduce the 3 a.m. hours during the week, and so left the 3 a.m. permitted hours available to the club during the week, and reduced them at the weekend from 3 to 2 o'clock, because it was at the weekend that the major issues were experienced. That's my understanding of it. I wasn't involved in that case, but that's my.
So you do not agree that the applicant at the time stated that the club didn't operate past midnight during the week?
Well, I'm not in a position to dispute that at all. I'm just saying that the premise, as I understand it, the premises were trading during the week, but as to whether it was traded to midnight or 1 o'clock or 2 o'clock or 11 o'clock, I simply don't know.
Well, Thank you. I mean, RBKC knows, and the licensing committee should know that from the records, and the residents do know that it wasn't operated past midnight during the week. Do you agree that that the potential for disturbance is dramatic if you have 4 extra days of post-midnight operation?
Sorry, it's extra.
Correct. 2 days operated past midnight versus 6 days operated past midnight, which is what you proposed.
I don't follow the question. Sorry. I mean, I'm not.
The club did not.
Ask somebody else to answer it for you, but I didn't follow the question.
Previously, the site was only open past midnight 2 days a week. You're proposing to open the site past midnight 6 days a week. Do you agree that 4 more days of past midnight is a potential for significant nuisance or not?
There's always potential for noise disturbance. There's always potential for it. It's a question of how it's managed. And you will know that a genuine purpose behind this application is to manage the premises in a way which did not cause the problems which occurred before. And one remembers the committee's final conclusion, which of its decision in 2016, which is that it wasn't so much a question of hours, it was a question of management. The criticism was of the management, and they removed the DPS and so on. So look, the applicant sympathises with your position because of the history of the place. But the reality is that the existing license, we're talking here about the license as opposed to operation, although operation informs the license. The license permits the premises to be open until 3 a.m. Monday to Thursday. Now, you will know that notwithstanding the fact that the license permits that, this applicant has voluntarily said, reduce those hours from 3 until 2 o'clock during the week. So it is already offering a considerable reduction in what the license currently permits and which can be used tomorrow by this applicant or any transferee. I think that's the best way I can answer that question, but we sympathise with your position.
Okay, then I have a question as well. You mentioned that on quite a few points that you're not prepared to micromanage. Do you not agree that the only way to avoid nuisance, given the proximity of the site to the resident's home and the whole history that you're well aware of, do you not agree that the only way to prevent nuisance is in fact to micromanage and ensure enforcement?
Yes, absolutely, I would agree with you there. Micromanagement is the responsibility of management. And they have to micromanage every aspect of everything, which is very much what's intended here. I suppose when I mentioned micromanagement, there is a concern in relation to enforcement and conditions on premises licenses that perhaps there should be an avoidance of micromanagement for the purposes of conditions on the license. But the micromanagement element, of course, is an absolutely essential for example, the entrance and egress plan, which you as a resident and the Residents Association would be a consultee on under the conditions of the license, and that would be involved the necessary micromanagement of what happens. I totally agree with you; it is necessary.
Okay, and then I have a question, perhaps for Sue. We're left a bit confused because there's a lot of talk about how the SIAs basically are going to be the only people that are going to prevent the nuisance. There's been talk about the SIAs patrolling constantly around the square, and at the same time, there's talk of them blocking Derry Street and blocking patrons coming out of the club. Presumably, they should also be blocking patrons from parking and walking into the club. Now, this is a big square, so the walk around is 152 meters, and there is no line of sight between the corner of Derry Street and at least 2 of the sides of Kensington Square. So, how many people are you going to have fixed station on Derry Street to prevent people from going from Kensington Square into Derry Street and from Derry Street into Kensington Square? And then how many people are you going to have patrolling around? Because we do not think the same people can do both jobs, and you're basically setting them up for failure.
Hello, Mariella. Thank you for your question. Sorry, there's just some. Okay, thank you. Right, so the simple answer to that is as many as it takes. We've already committed in our application to the minimum number of SIAs, but as far as I'm concerned, it's as many as it takes. And this is very much going to be a part of the ongoing discussions that we have at our monthly meetings in terms of the numbers. Are they working? Do we need to have more? I certainly don't envisage having two people, say, at the entrance who then do regular patrols and leave their post. I would always expect somebody to be at the entrance and somebody to be patrolling so that we still have those sight lines to the club. But like I said, I'm very, very happy for this to be very much part of an ongoing discussion with you in terms of what works and what doesn't work.
We've seen operating plans and how they don't work and they're not enforceable, and how after an application is granted, everybody always refers to the conditions. Would it not be better to have the condition having more clarity, that you would have 2 people at the corner on Derry Street and 2 people patrolling, so 4 people with certainty?
It's really necessary. You said this needs to be done.
Sorry, forgive me. Yes, as far as we are concerned, Mariella, there are already conditions which make it very clear as to the number of SIAs that will be both patrolling and stationed at our door as well as on the square. And as I said, this is a starting point, and sorry, forgive me. This is a starting point, and it is very much part of what I have always said will be an ongoing dialogue with the local residents. I will make myself available every single month to sit down with you to have these discussions to make sure that what is already in the conditions works, and if it doesn't work, then we're prepared to adjust it.
So you would not like to offer a condition now that there's going to be two people on the corner of Derry Street not moving from their post and 2 people patrolling?
Well, do you mind if can I deal with that? Lawyers can sometimes get in the way and sometimes can help, but we always have to give legal advice. The problem about from a legal perspective, the problem about conditioning now precisely the number of SIA staff who must stand on precisely which corner and in which element of which part of the square is that it doesn't allow for flexibility. And it would mean if they weren't so positioned, even though everybody agreed later that they might be better positioned 20 odds up the square or whatever it is, you couldn't do that without coming back to the licensing authority and applying for a variation of the condition, breach of which would be a criminal offence. So there are some aspects where it is right to have the enforceable condition, that is to say that there should be X number of SIA on duty doing a particular function, but to pin it down by way of an enforceable condition, breach of which is a criminal offence, as to precisely what they do and precisely where they are, we say that is the stuff of an organic changing management plan rather than permissions to be imposed on the license. That's the position from the legal perspective.
Stephen, the residents know what is required because we've lived next to the premises for years. So yes, with respect, we know where they need to be stationed and we know that what they should be doing. So I do not understand the resistance.
Well, I don't think I can explain myself any better than I did before.
We're asking for one more person, so 4 versus 3, Stephen. You know, that's it.
I don't think we're that worried about numbers. It's precise positioning that's the issue.
Well, the positioning can be discussed later, but I'm
You can
saying
quite agree.
minimum of 4.
Yes.
Commit to 4, and then we can agree the detail with Sue.
I see. The suggestion is that there should be 4 SIA patrolling the square.
And station. 2 station, 2 patrol. That's what it is.
Two station, 2 patrol.
That's what
Yes, well, in that case, yeah, that is the kind of condition that would be enforceable and appropriate. And as you say, the precise where they stand and what they do would be the matter of discussion. So yes, is the answer to your question about a condition. 2 patrolling, 2 standing, 4.
Can I just interject here? So you've previously agreed to an additional 3 SIA patrolling the square. You are now agreeing to 4. Is that correct?
It was
Yes.
previously 3
With some patrolling.
with some patrolling. We're now saying 4. Yes, exactly.
Okay, so the
It
other
was
2.
3, some patrolling, some standing. We're now agreeing to 4.
Yeah, I think on Sundays to
14.
Wednesdays after 10, you're agreeing to 1 SIA on the door. And on Thursdays, Fridays and Saturdays after 10, you were agreeing to a minimum of 3 SIA on the door. So 3 and 1. And then in addition to that, you were at that point saying 3 on top of both of those additional patrolling. So now you're saying an additional 4 to patrol rather than 3 to patrol.
Yes,
This is 7. They said earlier in the hearing it would be for 7 days a week,
Yes.
Lindsay. So it's 7 days a week. It's 4 on the square, at the entrance to the square and in the square, 2 and 2. And then it's a further, is it 2 or 3 at the door, 7 days a week.
Yeah,
I think one of the existing conditions was Sundays to Wednesdays, 1 SIA on the door after 10.
Yes,
Thursdays to Saturdays after 10, 3 SIA on the door. So there's 3 and 1. And then...
I think the position is that 46, 47, I don't think have changed, but 48, an additional, this is about the additional, 48.
Yes.
An additional 3 SIA door supervisors shall patrol Derry Street at Guernsey Square at intervals.
You're saying 4 now?
We are saying 4 now.
Yeah.
Okay.
After 6 p.m, yeah.
Yes, that's right.
So
After
it's-
6 p.m.
And Stephen, that needs to specify that it's 7 days a week, which at the moment it's not clear.
Well, at the moment it says, yes, I see. That's the intention. Yes, well, it should be clearer. Yeah, I agree. SI registers shall be patrolled Derry Street, Kensington Square, at regular intervals.
I'll take out on Fridays and Saturdays. If that
Yes,
is
take
possible,
out on
yeah.
Fridays and Saturdays.
Yeah.
And that's clear enough then, yeah.
Thank you.
Yes.
Okay. Thank you very much. So I think we have, I think the last question from Mr. Oyen, if I remember correctly, would be useful if in future people put their full names. But I do appreciate that it's not always the easiest thing or the most obvious thing. So Mr. Oyen, please ask your question of the applicant.
At the risk of sort of beating this to death, I did want to review the parking thing again, because I think it's an example of what the issues are with this license. And first, I want to put it in context for the applicant to understand why the residents have spent so much time on the parking issue, which I think is just, one minor issue of a lot of other bigger issues with operating this thing until 3 a.m. Part of the reason people focused on parking is, we've had the introduction of the Whole Foods. The council sold the NCP park here that was on the square. And as a result, we've lost a lot of parking capacity while increasing the amount of flow into the neighborhood. And this is just going to exacerbate that a bit further. And when I look at these proposals, just kind of big picture, what we're being told to control, members accessing and parking in our square, it really comes down to, if you register a car as a member, you can't use that car to come to the club. If you don't register a car, you can bring that in, or you come with a guest, or you come with someone else. It's only the registered card that will be restricted from coming in. The geofencing, if I understand it right, deals with pickup. But, you know, people are people. If Uber drivers, taxi drivers know that you're coming to the roof garden, they know they can just drop you off right in the square and you're 20 feet away from in the club. But I think the bigger thing I'm concerned about is this is an example of, you know, things we're concerned about, and it all comes down to the same thing, which is this is a promise of the operator. The enforcement relies on the behavior of the operator. There is absolutely no recourse for failure. It's trust us, promise us, we'll do our best. And, you know, and what is that enforcement even of the operator? I think the whole point was trying to make the distinction between private members club and a club open to the public. But again, what are you going to do to your members? Nobody's actually said, this is the enforcement we are, as operators, going to take. If we find a member in this simple, silly example of parking, who parks in Kensington Square or has an Uber drop them off or a taxi drop them off in Kensington Square, nobody's said on the operating side, we are going to make it clear to you, this is the enforcement. Because we're asking you to act against your own financial interest in order to protect the neighborhood. Are you actually going to terminate, which is your power as a private members club, someone's membership because they repeatedly park or walk through Kensington Square? You've never said that, and I find it hard to believe that you would actually go that far. My suspicion is it will be a warning, please don't do this again.
Well, the question, as I understand, is if someone repeatedly parks in Kensington Square in breach of the terms and conditions of their membership, would they be relieved of their membership? And the answer to that question is yes. And I'm just going to allow, given this is the last question, for Sue Walter to deal with that. Very good question.
Thank you. Hello, Peter. Yes, just to reinforce what Stephen has just said, and forgive me because I do believe we have said this several times, including at the hearing and when you came in to meet with us, it is a condition of membership of the roof gardens that our members behave in a respectful way to our neighbours, to our staff, to our community, and that includes following the rules of being a member of the club. One of the explicit rules of being a member of the club is that they are not allowed to park in Kensington Square, even if they are a local resident and they have a residence permit. When they visit the club, they are prohibited from parking in the square. If they break that rule, along with any other rules of membership, our recourse is termination of membership. And it has nothing to do with financial interests. And as far as I'm concerned, it has everything to do with the integrity of the community that we're trying to build. And if they do not operate within the rules of our community, I will have no hesitation in terminating their membership.
If you don't mind, I'd just like to jump in on that, Ms. Walter. I think just to address what Mr. Owen is saying, what you're asking for is a license which would outlive the operator. And what we're doing here is coming to a legally binding decision. So what he's saying is, what's to stop you just changing your mind, which is why we want to make this a matter of condition, or why they would like to make it a condition, and what's to stop a future operator if, the worst happens and, it all goes under in a month and somebody else takes over, they will have that license too.
Understood. I can only reinforce that it is a condition of our membership rules, which we're very happy to share with the committee and with the residents as well, that failure to adhere to the membership rules will result in termination of membership.
And that as a condition, of course, that is to say that it must be a condition of members that members do not park would survive. I mean, there's no intention was not to be here for the next 20 years, but I mean, you never know, I suppose. But that condition would remain on the license. It would survive priestly operators and premises. I understand the point, Chair, which you made, which is that, well, that may be so, but how do we know we're going to they won't just ignore these breaches? Well, that of course at any time would be a subject of enforcement, of review, and if things weren't properly managed and they weren't adhered to, and there weren't teeth behind the elements of those conditions, then it would be perfectly proper for the licensing authority to intervene about it. But of course, this brings us right back to the point of this hearing to some extent, and that is that certainly in relation to the 3 a.m. issue, we're looking at a temporary period. If things go well, we have to be back in front of you in 18 months if this application is granted for a variation. So I can't remember the name of the case now, but there was a case a number of years ago in the High Court where there was a concern about, well, although you might be a good operator, the trouble is that these are difficult premises and there might be a different operator later on, a different holder of the license. And the decision of the court was that you can't speculate as to the future. One can only deal with an application which one has in front of oneself at the time. But we do take your point, Chair, about the future, and that's why, in fact, so many concessions have been made about the extant license. So many voluntary reductions and reductions in the scope of the license, very unusual, have been made by the applicant because it wants to develop into the future a good relationship with the community. Because if they don't, it's just not going to work at all, and they know that.
Understood.
Right,
Thank
but
you.
I think
Sorry.
I was.
No, go on, Mr. Owen. Sorry, I can see
Yeah, just big picture. I think I was picking up on the parking thing because I think this is another example of what we're trying to do here. Is we're trying to pound a square peg into a round hole and coming up with a convoluted set of issues trying to address an issue. For example, parking, which has actually no enforcement for the residents. It is truly trying to pound the square peg in a round hole, and it's going to work because we just have to have faith in the operator to be able to achieve this. And for your benefit on the applicant side, the skepticism is because of what we lived through in the past. And I can tell you, these operators ended up, losing the license, having it restricted. They suffered severe consequences. There was true motivation on their side to try to make this work by operating a nightclub till 2, 3 a.m. in a residential neighborhood, and they failed. But there was no lack of motivation of trying.
Yeah,
but they failed, and we're being asked to set this up again.
Mr. Owen and Mr. Walsh, if you don't mind, I genuinely appreciate the sentiment that's being laid out here. There will be time for objectors to make the case fully as well. I feel.
No, we can move on. I just wanted to make that point.
Toby, you're on mute.
Yeah.
My apologies. What I said was understood and appreciated, Mr. Owen. So before, so I think we'll have one final question from the objector, and I think one final point, and then we'll be taking a 15-minute break. I see that Heidi, one of the legal officers, has a hand up. Is there something you want to interject?
Yes, thank you, Chair. If I just following on from Stephen's suggestion that there's a condition that can live permanently, that no members can park in the square. I just wondered if you could help me, Stephen. does that condition just refer to members of the club? It wouldn't apply to private guests,
Yes,
private events or guests, or would it? Could you
yes,
please
it would.
just clarify that?
Yeah, absolutely.
Thank you.
So condition 16 on the amended as we have it at the moment is it will be a condition of membership and any private booking that patrons and their guests must not park in Kensington Square or adjacent streets for the purpose of attending the premises.
Thank you very much.
Lovely, thank you. Okay, so one final question from an objector, or well, Dory, would you like to make your point before?
Yeah, thanks. It's a question.
Okay.
Yeah, okay, thanks. It's a question I suppose one could direct to the applicant as well as to Mr. Sterling. It's about the direction of the levers, you know, direct them to Ken High Street and all that. But the question is, you can only do those so politely, so to speak. But if someone needs to go to Thackeray Street, for example, Kensington Square is not a closed square. So if someone has a good reason to go south, if I may put it like that, then how are you going to stop them? And actually, that brings me to the, what grounds do you have? What reasonable grounds do you have to stop them? I'm not saying there are lots of people. There could only be 5%, 10% of all the levers. But also, when you speak of not parking in adjacent streets, do you mean only Young Street and Thackeray Street? What about Kensington Court Place and so on? Thank you.
Well, so the answer to the first part of that question is we can't stop people from walking through Kensington Square because it's a public highway, and neither can the police. But there's a difference between that, preventing people going through the square and discouraging them from doing so. So you have a membership scheme by which you can't park there and where they're discouraged from going on through there. And then when you have guests, you direct them towards the high street. Of course, you can't prevent in every single set of circumstances anybody going anywhere near the square. But we would say that with the suite of measures that we now got in place, those who might be doing that would be the exception to the rule. And they wouldn't, just because they're going through doesn't mean to say they're going to be shouting and noisy either. It's about developing a package, but we accept, of course, that we can't pin people to the floor and not allow them to do things that they want to do.
Thanks. And would you define the neighbouring streets regarding parking?
Oh yeah. Sorry, I should have.
We'll come back to you.
Yeah, can we come back to you, Councillor, please, on that?
Yeah, sure. Thank you.
Okay, thank you. Now I've seen the hand has disappeared from Miss Alexandra. Is there no question?
No, my question was just asked.
Oh,
I
lovely.
was interested in the neighbourhood and not just the four corners of Kensington Square.
Yeah, gotcha. Okay, well, in that case, I'd like to call a 15-minute break. So if you could all be ready to start again, and let's just round it up to 12:15.
Yes. Chair, I wonder if I might just ask, it's a personal question, really. You may not have a view about this. Were you anticipating completing the hearing by lunchtime today, or not? Or that's just quick.
I wasn't anticipating anything. I've kept the day free. My preference is not to have another saga.
No.
But I'm afraid I can't make any assurances.
Thank you very much.
Okay, so that makes the beginning. Excuse me while I do my normal fiddling with Windows. But yes, let's take a break till and be ready to start again at 12:15. Thank you very much.
From fences.
Hi everyone, thank you for rejoining on time. I think the committee are just in their kind of separate meeting, probably making sure they've covered all the points they need to, and they'll be joining us very shortly. Thank you.
Hello all. Apologies for going slightly over. Just drawing everyone's attention that we're beginning again. Just give a second. There we go. Okay. So, before we actually move on to the responsible authority, I believe Lindsay, our legal officer, has a clarification that now would be a good time to make. So, please, Lindsay, go ahead.
Thank you, Chair. Mr. Walsh, can I just clarify one point? I think I know the answer, but I just want you to confirm it. Is it only your time-limited condition that is time-limited, i.e. none of the other conditions that you've proposed, that have been amended, that we've discussed, that have been added, a time limit? It is only just the one condition, none of the others. Is that correct?
Yes, that's correct. That's in relation to the 3 a.m. on Fridays and Saturdays. Yes.
Thank you. That's all I wanted to check. Thank you very much. Thank you.
Excellent. Thank you. Okay, now it's time for the responsible authority, Environmental Health Officer, Mr. Keith Mahaffey. Mr. Mahaffey, can you please present your submission? Please turn your camera on if you would like to, and you have up to 10 minutes to do so.
Thank you, Mr. Chairman. I'm having problems with my internet this morning, so it's probably best if I don't put my camera on in case it goes down. Basically, my concerns are outlined in my representation. Basically, this amendment, in my opinion, is fine and good, but what if the external management doesn't work? What will be the impact that it will create on residents? And in my opinion, that will be very significant. You can be disturbed significantly at midnight, never mind 2 o'clock and possibly 3 a.m. in the morning. Residents get very, very sensitized to noise in the street. As I say, it's a dripping tap effect. If the tap drips, you're lying there waiting for it. If it doesn't drip, you're still lying there waiting for it to drip. And if it doesn't drip, you're still stressed. And this is the situation that can happen over a period of time with residents and their perception of noise. Now, I welcome an awful lot of the proposals that the applicant has made, and I don't want to be a person who's saying that they're being irresponsible. They are being very responsible in what they're trying to deal with. They've got an application which basically wants to go to 3 a.m. in the morning. Now, the activities inside the premises can be contained inside the premises. Purely the issue from the public nuisance side is the people dispersing. And the very, very best external management plan is only as good as it is enacted. And the problem, if it is not enacted correctly, then it will be very problematic for residents. It will have a significant impact. I'm sorry about that. My internet went in and out. It will have still a significant impact on residents. Now, I have no illusion that the premises will do everything in their power to get it properly implemented. But some of our very best premises in the borough, they still get things wrong. And that's the way in which it works. You cannot have an external management plan that's going to be operating effectively at all times, and you can't control things at all times. And this is where I consider that there will be a significant reactive nature to the disturbance that will be outside the control of the applicant. I've seen people coming out, as I said in my previous submission, coming out from a club in the King's Road and going into a rugby chant. Nobody could deal with that. It was purely a reactive situation. And if people are in Kensington Square, the sound reflects round. There's no protection, no acoustical protection can go on windows. There are children sleeping. This is a 6-night-a-week event that can go up until 2 a.m. in the morning and 3 o'clock on a Saturday and Friday and Saturday. And those are the impacts it will have on residents. Residents won't be sleeping. Children will be kept awake. all those sorts of things will have a significant negative impact on them. I honestly feel that, you know, what they've put forward, while it is welcomed, it isn't far enough. I prefer to go back to midnight, and anything after midnight should be on a temporary basis. And I also feel that there should be a period of time of 2 years for that to occur. And in those 2 years, I think there should be more negotiations with the landlord to get an exit onto Kensington High Street. I accept that there will be occasions when people will have to exit into Derry Street if there's a requirement in Kensington High Street. There'll be people who will be disabled. There'll be people who will need to be able to use the lift. But the majority of 450 people who leave after 1 o'clock in the morning will need to be able to be taken away from the premises, and for Kensington Square to be made as remote as possible so that they don't go in and disturb them. That's really all I can say on this matter, sir.
Thank you very much, Mr. Mahaffey. So first questions from committee members. Colleagues, councillors?
I don't have one at the moment, thanks.
Councillor Graham?
Nor do I, Chair. Thank you.
And that makes 3 of us. Okay, so questions from legal officers. Lindsay?
Keith, can you just clarify what your view is on the current proposal, the time-limited proposal for 3 AM for 18 months and then reverting back to 2 AM? Do you have any comments on that aspect at all?
Well, I take the view that residents will be disturbed, be more disturbed at 2 AM than what they will be disturbed at midnight. It will eat into their sleep. I feel that granting a permanent terminal hour for 2 AM under this license is something that gives me concerns, because we don't know how the external management plan will work and whether they will be able to manage their people in outside the premises up until 2:30, 3:30 in the morning for that will not impact on residents. Clearly, I would like something a little different. I would like a midnight terminal hour and a 3 AM temporary for 2 years, so that we can consider that as a basis for the external management and give them the opportunity to prove themselves, and then for the 2 AM or 3 AM to fall away until and them having to come back. That's my personal feeling on this.
Okay,
thank you. No more from me.
Thank you, Lindsay. Okay, in that case, questions from
Chair.
Yeah.
Chair, can I just clarify? So Keith, the proposal on the table is it's just Friday and Saturday to 3 AM for 18 months. That's the time limited proposal.
Yes.
Can you just, so as I've understood it from what you've just said, are you saying you're okay with that time limit proposal to 3 AM for 18 months or not? I wasn't clear.
I'm not. I'm not. I feel that that if there is a proposal, that the hours that they've asked for after midnight should be all time limited. But I would think a longer period of 2 years rather than 18 months. Personally,
so just to clarify, Keith, this application is for a permanent license. Okay, they've actually applied for a permanent license. So everything will be not time limited apart from the Friday and Saturday until 3 o'clock. Now, the committee, as you know, cannot impose a time limited condition to the rest of the week, because they can't alter the application from a permanent to a time limited without the consent of the applicant. And what the applicant's saying is they will agree to a time-limited condition on Fridays and Saturdays only. So the committee has no power, and I need to make this clear because we have residents here, that the committee has no power to make this application time limited Monday to Thursday or on Sunday nights. So I just want to make that clear because you may wish to comment and clarify your representation.
Yes.
Heidi, can I just jump in? I think the time limited aspect is for Thursday, Friday and Saturday till 3 AM for 18 months. Not
Yes,
just Friday
sorry,
and
that was
Saturday.
correct. Sorry, Thursday. I said Wednesday. So it's Thursday, Friday and Saturday. So that's the only time limited condition that they're offering. They're not actually offering to transfer this application to a time limited application. They're only prepared to give a time limited condition for Thursday, Friday and Saturday.
Yes, I understand that, Heidi, and I appreciate that the committee can't impose that. But it is my concern that anything after midnight will have significant impacts on residents as long as people are departing into Derry Street. And that's the concern that I have with this application, is the fact, even with good management and responsible operators, which I have no issues with the way in which they put forward things, but there will be impacts on residents, and those impacts will have significant negative influence or problems to residents.
Okay. Thank you very much. Thank you very much, Heidi and Lindsay and Keith. Now for questions from the applicant. I'm assuming Mr. Walsh.
Well, I wasn't going to, Chair, but Mr. Mahaffey, it's really the same question that I asked of you on the 8th of February. I hear what you say about midnight, but of course there is an existing license which is not subject to a review, by which the premise can trade until 3 o'clock in the morning on Monday to Thursday and 2 o'clock on Friday and Saturday. That's the existing permission, and this isn't a review of the license. Are you still saying that this application should be limited to midnight, given that there is an extant license permitting longer hours during the week than we are applying for here?
What I'm saying is the fact that this application is a separate application from the existing license. It's a new application which is considered on its own merits. What I'm bringing to the committee this morning is my concerns with regards to the impacts that it will have on residents after midnight. The committee will make a decision whether their opinion it is acceptable to grant after midnight, and grant in the manner in which your clients have suggested. But at the end of the day, the important thing is that at the hearing is that these issues are all considered and brought to the forum, and that's my personal opinion.
Yes, all right. Well, I thank you very much. I agree with you. Thank you.
Thank you very much. If there are no more questions from the applicant, we will move on to the objector's submission. I'd just like to add something at the top of this part. I see the hands going up. That's great. You are all entitled to your time, and it's very important to us that you will feel that you've been heard. I will make a request, perhaps a strong request, that we not go over the same points that we went over on the previously convened hearing. Also, to not repeat each other's points or anything that's been put in emails, and just to have some perhaps some faith. I mean, speaking as somebody who is really only in this position because I started campaigning against local development, I am, I understand that there's you have a lot of very strong points, and it's really important that you get heard. But I do ask that you not go over the same things over and over again. and that we sort of keep it focused on the particular remit of this hearing, because believe me, we have heard the evidence, we are weighing the evidence appropriately, and we take this very seriously. And thank you for taking that on board. So the first question, the first hand I saw go up is Ms. Cowley again. Please make your presentation. And we did give a little extra time to the applicant, so in theory you can go over a little bit over 10 minutes, and your time starts from when you begin speaking.
Okay, I do hope you can hear me. It's all a bit weird. I want to assure the committee that I have searched very hard for an alternative to the cliche actions speak louder than words, and I have failed, so I'm afraid I'm going to have to use it. The applicant has repeatedly said that they're prepared to operate with the existing licence if they are unable to gain the new one that they've asked for. I would therefore like to highlight some of the implications of that choice, which the applicant has not, as far as I'm aware, discussed. In the existing licence, there is no permission for any licensed external activities, none whatsoever. As far as I can make out, there is no permission to use the Esme building or the Tudor Walk for licensed activities. So none of the planned activities that we've heard about for those areas could happen. In addition, there's no permission to have a cinema. Put those together and there would be a significant hole in the applicant's business plan and their stated methods of giving a great experience to their members. In addition, we've heard a lot about their temporary condition on shortening the time, Monday, Tuesday, Wednesday, etc., from 3 till 2. We need to bear in mind that that's probably going to be the quietest time that they're open, and that by closing at 2, they will probably save themselves money, because keeping the building open with all the staff for that extra hour with very little income would not be feasible. So with their stated intention of using the existing license if they can't get the new one, there's going to be, as I say, quite an impact on their profit margin. The question immediately rises, why would an astute business do that to itself? Why would it follow a course of action which dents their profits and services so much? The most obvious reason is that this is preferable to having a temporary license. So then the question is, why is it preferable? If the applicant were genuinely confident that the conditions could be met, they would have no real objection to accepting the temporary license. The fact that they don't want that suggests very strongly that despite their words, they do not in fact have the confidence that those conditions could be met. Their action of choosing the existing license over a temporary license is what I referred to at the beginning as actions speaking louder than words. I believe that they're not in practice confident that they can control the noise, not confident that they can control the parking, not confident that they can control the antisocial behaviour. If they were confident, they would be saying, bring it on, we'll show you. But they're not. If they don't have full confidence in what they can do, that they can do what they say they can, why should we, the residents, be confident? Why should the committee be confident? And this is has been mentioned, a permanent licence. So what confidence can the committee have that if this applicant fails to control those factors, a future owner of the business would be able to? There's a second point, and that is the issue of how this case is framed. What factors should be taken into account and under what concepts? What I haven't heard the applicant address is how they assessed the externalities of their business. There may very well be some people in the meeting who are less familiar with the concept. So very briefly, an externality is a concept in economics which points to effects of carrying out the activities of a business where the costs are not borne by the business itself, but by society. Although it's been around since the 19th century, it only came into general awareness in the 1990s over the questions of carbon emissions and the environmental damage caused by the extractive industries, and led eventually to the principle, the polluter pays. This isn't some arcane bit of economics trivia. This is an important moral question, one which society is increasingly having to grapple with, and which opens the ethics of the company to public scrutiny. Externalities include impacts on people's health and well-being. In this case, the impacts come from noise and antisocial behaviour. The effects of these on people's sleep, etc., are well documented, and we went over them at great length last time, so I'm not going to do it again. But the applicant appears to have reached the conclusion that the burdensome cost of these externalities is a fair price for us to pay so that their members get a great experience. I reject that assessment, and I ask that the committee do likewise. I would in particular ask them to enforce the council's own policy, which lays down that licences to operate after midnight are not to be granted. Failure to do that will be to allow the full weight of these externalities to fall on us. Thank you, Chair.
Thank you very much, Ms. Cowley. Number 2 on the list that I have is Mr. Oyen. And also, could I please just remind people to put their hand down, just so I don't get confused. Thank you. Mr. Oyen, please make your presentation now.
Thank you. Sorry, it took me a moment to get the mic activated. Well, that was an incredibly difficult representation to follow, so I will be simple. I mean, part of the new license and this permanent license does involve the expansion and the intensity of use of this property, as Catherine went through, opening up access and use of a much larger space in the venue. So I think keeping it simple, I would not be in favor of granting this license as requested now. It will increase the intensity of use. I do think there is an opportunity here if, their intent on opening under the old license, they do so, and then they prove to all of us not only that they can manage this situation and this large number of people basically going to a party 6 nights a week, but also importantly, they back up their promises. And so if we do run into issues operating on the current license, that they can demonstrate to us that they have done what they've promised, because we are totally in their hands on enforcement. We have no recourse once this license is granted. We're relying on their promises to manage it and to use their power as a private members club to exclude members that don't adhere to their rules. So I would be more in favor of proceeding on the existing license and then seeing how they actually manage this flow of people and the noise. And in circumstances where they haven't been able to manage the noise, they can demonstrate to us that they fulfilled their promises and those members have been removed from the club. Ideally, I agree with the responsible authority if they want all the benefits that they're asking for in their new license, that they voluntarily agree to close at 12 if they want all this benefit from day one. Otherwise, I think, we give this a try on the existing license, see how it goes.
Thank you, Mr. Owen. You have more time if you want it.
No.
Okay. Thank you very much. So far, yes, there's only one more hand I see up, which Ms. Picciotti. Please present to the committee.
Thank you very much, and thanks to my previous residents who have covered almost everything that I wanted to say, so I don't think I'm going to be using my 10 minutes, but I do want to talk about some technical points that we have put down in our representations, but we do need to repeat those because the applicant has stated again and again a lot of talk about the old license. This is a new application, which we believe in the same way that the responsible authority stated has to be considered on its own merits. This is very clear in law and also in RBKC's licensing policy. So this license cannot be looked as a review of the old license. It needs to be looked at in isolation. We are confident about the history and the facts of the disturbance that the site produces given its proximity to residents' home. I hope we have presented all those in a factual format and not opinion-based, but you can see that the disturbance has been historical, has not been caused by one operator. It has been multiple operators over decades, and this was again on an operation that was only 2 days a week post midnight and not 6 days a week post midnight, which is what the applicant is proposing. We are discussing with this new license 3 times the level of disturbance as a result. There are no concessions made that basically give us any security because the words that are being used is discourage instead of prevent, and the applicant themselves has admitted that they cannot stop people from walking into and out of Kensington Square. This is a democracy and there's nothing they can do about it. So to us, this license is new, this license is permanent, this license is not on this operator, and their main case hinges on their reputation and their will. At the end of the day, they have not operated a club on the site before, but all of this is irrelevant because, as we have stated, the license is permanent, is on the site, not for them. Tomorrow, the owner could decide to sell the site, its long lease, and its license to a new operator. As a result, we strongly believe that the new license should be refused or given only a new license until midnight, because this is in line with licensing law and policy. And then if the committee is minded to approve the application, we recognize that they cannot force the applicant to do a time-limited license, which is why we still believe that it should be stopped at midnight. We would urge some additional conditions. We don't agree with the new representation to remove photographic evidence from condition 61. We think that everybody should be photographed, including guests, and we know multiple private members clubs that do this. Upon members and guests entering, they are photographed. And we also think that the removing of the condition 72 protection by possible forfeiture proceedings should remain as is. We do not think they should be removed. Then finally, and I'm sorry to go back to a point we haven't discussed on this committee, but we left it open at the previous committee. If the committee was minded to approve longer hours on a temporary basis, as suggested by the applicant. We had discussed about how to monitor noise and camera. We had a meeting with our members, and we have agreed to put noise and camera equipment to monitor the noise from the egress and access onto Kensington Square. This would have to be done on one of the residents' homes, I guess, buildings. So we would like that to be a condition to be funded by the applicant, which I guess was previously discussed, I think, at your suggestion, Councillor Benton, but we didn't know how we would implement that. So we would be happy as long as the applicant funds that to organize that, but we would like that to be the funding to be a strong commitment and a condition.
Okay, if that's the if there's no further presentation to be made, thank you very much. And thank you very much to all objectors who presented. So, firstly, questions from the committee. Would either of my colleagues like to kick things off?
Thank you. Thank you very much. From the last 2 or 3 presentations, it seems to me, in summary, the objectors prefer the existing license despite the long hours because of the fact that the fewer areas are covered. If I understood that correctly, then I have to say there's nothing to stop the applicant asking for a variation. That's the question to the objectors.
Yes, we understand this, and the variation would undoubtedly go to committee, and we would look to make representations at the time. We do not think it is appropriate for RBKC to grant a brand new license with a terminal hour post midnight. If this is to be dealt by variation of the existing license, again, that would be a separate process, and we would be dealing with that.
Thank you.
Thank you. That's clear. Councillor Graham, anything?
No, thank you, Chair. Dory just covered what I was going to ask.
Excellent. Okay. So, any questions from legal officers, Lindsay or Heidi?
No questions from me to the objector, thank you.
The only question, Chair, is that as the last resident suggested a condition about this noise monitor being funded, that is a question that we would need to ask Mr. Walsh as to their view about that. Perhaps he could mention that when he asks questions.
Okay, come back to it.
Do you want me to assist you there, Chair?
Yes, please.
Yes, please.
Sorry.
That's what I was trying to figure out.
Yeah. So I'm afraid it's a 5-sentence answer rather than yes or no. It begins with yes, we would fund that, but all the expert evidence is, and our own expert, Mr. Charlotte, is that it is unnecessary to have monitoring points in the residential noise-sensitive areas, because the most effective monitoring point is that which has already been chosen, and it is on the corner of the south side of the building itself, which effectively is the barrier. But that said, if it would assist residents to have a monitoring point in one of the closest noise-sensitive premises, then I'm sure, in fact, I'm looking, and yes, we would assist with funding that, but
needs regular access.
It needs a permanent power supply, it needs regular access by, there are a number of issues that relate to it, but yes, we will.
I think we're talking across purposes. We are not talking about noise from music. We are talking about noise monitoring for the front terraces on Derry Street to monitor noise and to also visually record evidence from patrons coming and going. This would not be connected in the same manner. So this would be exactly as similar to the noise survey we commissioned and we paid for it. That's what we were asking, which I believe was discussed at the previous committee, but we because there's completely different parts of the noise produced from the music, which is permanent and sends alerts. We don't suggest that there is anything connected to your premises. We're talking about.
Yeah, my fault. I misunderstood. Well, I mean, all of that which you discussed will unquestionably be part of the monthly and at least monthly consultation. You hear what I say.
We are asking for it as a condition.
Well, we wouldn't be in a position. It would be very difficult to be precise about a condition of that kind. That's I'll say no more about it than that.
Yeah, thank you. This is actually sorry. This is the time for questions to be asked of objectors, and we'll get into conditions later. Okay, so if there are no more questions from legal, then 1 second. I'm sorry. Okay.
Can I just make a comment, please? It occurs to me. I think I said this before at the original hearing, but at the end of the day, if there really is persistent disturbance, and this is addressed to the residents in particular, and this is reported at the time, preferably with video evidence, not just sound recordings, but video evidence, we can call the license in for review, and we do that. We try not to, of course, but we can. So I just want to make that point again. Please, if there's a problem of any sort, whatever we grant, and in any license, not just this license, but any other license that bother any premises that bother you, report it, please, at the time. We get very few reports in general at the time of disturbance.
It's a very good point, very well made, and continues to require being made. But yeah, absolutely right. So now we questions from the applicant of the objectors. Mr.
Hand went up.
I understand, but we can perhaps.
Sorry, Chair. No questions from the.
No questions. Okay, thank you, Mr. Wald. Okay, no, I can see I can see we also have an objector with a raised hand. Is this relevant to the discussion we were just having?
Thank you, Chairman. My point is that I appreciate all the details that we're talking about here, but at the end of the day, we're talking about giving a permanent license for an increase in space and intensity on the business. And in exchange, what we're getting is to say that for temporary period, we're just it's just going to be temporary to have an extension even of the time of a couple of hours a week. So the fundamental issue here that I have is really the increase in the intensity of the customers that are going to come through the square compared to the existing license. So as my other colleague residents have said, I think it's much better that we check out first this management that intends to operate significantly differently, as Mr. Walsh said, from the previous operator, to see how they operate with the existing license, and then we will review if they want. And I appreciate that we can always complain to the council, but here I think we would rather prevent the issue or try to prevent the issues. Thank you.
Understood. Understood. Thank you very much for that comment. Okay. So at this stage, I'd like to ask our legal officer to deal with anything outstanding that hasn't been covered that needs addressing.
I think there's just one final point. I think the applicant was going to get back to me. I think it was the proposed condition 76, which says no customer shall be admitted to the premises later than 1 hour before the terminal hour for the sale of alcohol. And I posed a question about what if the committee were minded to grant lesser hours than salt? What would their view be then?
Not reduce hours.
Yes, I see. Yes, so the answer to that question is that would apply across the week, but our position is only if the hours which we seek under the application were to be granted, because if much earlier hours are granted, then it would make it rather difficult to comply, to make sense of such a condition, that condition being for later hours. But yes, we agree with that across the week.
Okay, so just to be clear, you're saying that you're only agreeable to that condition for the hours sought across the week?
Because it's a condition that relates to later hours.
Okay, so not early hours.
It's to stop people going to late night venue somewhere else, isn't it, really, and then coming to us.
Okay, that's great. Thank you very much. No more questions from me. Thank you.
There are a few, just about 5 conditions, which if we're going to be discussing conditions, I said I'd come back to you on.
Please do. Do that now. Yes, yeah, that would be perfect. Okay. You could do that now, thanks.
So condition 33, one of the concerns of the residents, certainly one resident, was in relation to controlled drugs. And that isn't provided for in the conditions at the moment, but you'll see condition 33. All staff responsible for selling alcohol shall receive regular training in the Licensing Act 2003, in terms of the licence, the objectives, offences committed under the Act, and the conditions of the premises licence. I haven't got precise wording, but they should also be trained in the impact of, I was going to say, controlled drugs. But the long and short of it, we agree that something like that should be added to that training condition.
Thank you.
Yeah. Okay, so that's 33. 36. As is currently drafted, we don't seek an amendment to the last time we agreed that the premises. So if you're 36 as is on your schedule agreed last time, but we can add to that: the premises shall not operate under this premises until a dispersal external management plan, the plan, has been submitted to the Royal Borough of Kensington Environmental Health Department, Licensing Authority, and the police and residents.
I think we were going to do Residents Association, weren't we?
Residents Association, yeah, for consultation.
Yeah.
With the rest of that condition remaining as it is, then
we were going to get Environmental Health to sign it off, though, weren't we?
Well, no. I think the position is that that there is consultation. The plan shall detail the procedures, measurements, and so on, as well as managing. The premises licence holder shall have due regard to any recommendations of the licence authority, police, and environmental health. That seems to me to be the appropriate way of doing a management plan.
Can I just ask for Keith, because during the main hearing, I think licensing, Mr. Eyeball and Keith Mahaffey both suggested that it be written or signed off by environmental health. Can I just ask them for their points on this, please? Sharon and Keith.
Sorry, it's Sharon Dybel from the licensing team. In terms of the condition, what we seek from environmental health and the police is, number one, that they have been consulted and they've had an opportunity to comment on it, not necessarily that they agree with what is within the policy, but that they have had that opportunity, they have seen sight of the policy, and that they have had an opportunity to make recommendations.
So not to provide written confirmation to sign off.
It would also put a significant onus on the applicants to basically require them to do what we actually ask them to do. You know, at the end of the day, we are not the experts with management control outside premises. You know, they know their business better than we do. What we want here is an ability for the external management plan to be reviewed on a regular basis, so that it can be something which is going to be appropriate for the premises. And at the end of the day, the premises have to take ownership of that, and we can't compromise ourselves.
So you don't want wording saying that you've got to sign it off, is that correct?
No, no, definitely not. We wouldn't want that, please. It wouldn't be appropriate, because if we have to take enforcement action, we can't be complicit in it.
Okay. Okay, thank you.
May I completely agree, and can I just, for the benefit of those here, the requirement to consult and to have due regard with environmental health and police and so on does, as Mr. Mahaffey says, place a significant onus on us to have full regard to and respect what is said by environmental health, because it can come back to bite a licence holder later on if proper regard is not given to it.
Okay, thank you for that. Do you want to continue?
Yeah, so there are more conditions we were going to hear back about, or is that? I'm afraid I don't have it to hand.
Okay, so the next one was just lost my piece of paper. It's just literally vanished into thin air. I'm now looking at the condition which requires parking. In any event, you'll recall while I look at it, the requirement in relation to the prohibition against parking in Kensington Square and neighbouring streets. We really thought about this, because it is very difficult to neighbouring streets was a phrase drawn from the existing extant licence, but actually to create an enforceable condition, and given that patrolling will only take place at Kensington Square, we actually think that should be Kensington Square only, because neighbouring
this is condition 16.
Yes, that's correct.
So it currently says, this is like the unamended version, it will be a condition of membership that patrons and guests must not park in Kensington Square or adjacent streets, and then there was something about except residents of the borough. So what are you now suggesting? Can you read out?
To take out adjacent streets, because I mean we don't mind leaving it in there, but we take the point of the resident earlier on. It is actually very imprecise to say neighbouring or adjacent streets, and given that patrolling will be in Kensington Square, I've got it. We think it better that we're in your hands about that. We're not making a strong point, but we think that's probably the better way of doing it. And then condition 42, which deals with queuing. There's a bit of an issue between the lawyers and the operators here, which door supervisors should maintain orderly queuing outside of the premises and should ensure there is no obstruction of the highway. Any such queue should be managed so as to run on the pavement. Mr. Sterling, I think, suggested there should be a condition, there should be no queuing, but we are very slow to suggest that such a condition should be imposed, because though it is not anticipated that there will be any queuing at all, one can see a situation in which one might have 4 or 5 people outside or whatever on an event, which if that occurred would be a breach of a condition of the license. So we think 42 is better expressed already as it is, which we agreed on the 8th of February, rather than imposing a complete no queuing condition.
Okay, noted.
So
thank you.
that's our view about that. 62. Condition 62, the sale of alcohol no, we dealt with that. We dealt with that during the course of discussion.
Yeah, we're going to break that down into 2 conditions. If the committee will mind to grant, and you.
Yeah, that's it. That's it. Thank you very much. No further from me.
Thank you. No further from me. Back to you, Chair.
Thank you very much, Lindsay. Next, we have licensing officers. Is there anything that Ms. Dybel would like to add?
No, thank you, Chair. I have nothing to add.
Thank you very much. And finally, governance officers, anything to add?
Nothing from us. Thank you, Chair.
Can I?
Okay.
Chair. Could you just
Okay,
ask,
Dory, go on.
Did the applicant? Well, I guess it's to the applicant and to our legal advisors. Did the applicant agree to hours on no rubbish collection as requested by an objector?
No, do you remember, that's instinctively what we want to do. But we think that that is part of the management plan discussions. One of the issues being that we don't have the bay in which rubbish is collected is not collected by our own private refuse collection. It's collected on behalf of the whole building, and then that's shared by people. So that would present difficulties, in which case we would have to negotiate with the landlord for things like.
You don't know where the hours are, because in general we can have such a condition.
Oh,
for
absolutely.
premises. Do you know what
Yes,
you
I
don't
think-
happen to know where the hours are?
I think, sorry, Councillor
No.
Smithing, I think at the previous hearing, in terms of rubbish and compacting, I think it was agreed at the previous hearing that this wouldn't occur between 11 p.m. and 7 a.m. the following day.
Yeah.
All right,
That
because
was- that was
it says no.
previously, yeah.
It says no deposition between midnight and 700 and 44 at the moment,
That's KOG, not the building.
We agreed to change it to 11 at the hearing.
which is not the same thing. It's just dealing with the deposition of rubbish outside, but not with the collection of.
No,
I think there'll be a
exactly.
separate condition for that as well. I'm just trying to find it. There's one
Yeah,
for deliveries, one for
It's not adjacent.
rubbish.
I just wondered. That's all. That if it's been aired and dealt
I
with.
think that's already covered in the previous hearing, to be fair.
It was, and we're not balking against it. We can see the merit of a condition like that. And in fact, as you identified, we've agreed to one already, but it's just in relation to refuse collection.
Yeah.
It is slightly troublesome.
You don't know the hours the building has. Miss Walter doesn't know.
No, we need to check on it.
Okay.
Can I make a phone call and know in 5 minutes?
We can make a phone call and find out quite quickly, I'm told.
Sorry, Lindsay and Stephen, there is a rubbish condition already that you've proposed.
Yes.
Condition 44, if that assists.
That's deposition. Depositing of rubbish outside. Not collection.
Yes. It
That's
doesn't
right.
do collection, yeah.
And I'm sure there was another one.
I'm going to let it, if anyone needs to figure this out, I'm going to give you a minute to figure it out, and then we need to.
Well, Mr. Walsh has said that they could make a quick phone call to find out from the, what it is. I mean, Chair, do you want to, or legal advisor, are you happy to do that? To wait 5 minutes or whatever?
If there's a condition to be proposed, it needs to be offered during the hearing. So the committee could adjourn for 5 or 10 minutes for you to do that, but we can't close the hearing again for you to come back to the committee.
Yeah.
No, that's what I meant. I mean, 5 minutes, I mean, a journal, whatever. That's what I meant.
We'll know in
Check.
2 minutes, I'm told, timing.
Okay, well, I mean,
Well, I
it
certainly
feels
don't
like
ask you to do adjourn.
it's just that wrong time, amount of time between, a minute and 10 minutes. But, okay, well, okay, how about we just adjourn for 5 minutes and we come back?
Very well, Chair.
Is that okay
Thank you.
with everybody? Okay, good. Well, I'm just going to, as chairman, and come back, just look at, well, let's just make it until 20 past the hour. Okay,
Thank you.
thank you much.
Yes, thank you, Chair. The answer to the question we've got is that the load bay does not operate between 10 p.m. and 7 a.m. It operates 7 a.m. to 10 p.m. The difficulty about that is that while it's within the hours that you anticipate, it's still not within our control. It's the hours governed by the building owner. And so I'm afraid the position remains that because it's not within our control, it couldn't be a condition. But those are the hours.
Thank you very much for that. Is there anything you want to add to that, Lindsay?
Yeah.
No, nothing. Thanks, Chair.
Great. Okay. In that case,
Could I suggest sorry, Chair, it just occurred to me, if those hours radically or substantially were to change, either earlier in the morning by an hour or later at night by 2 hours, could you have it part of your management plan that you inquire, should it come to light, you just inquire with the management of the building about that and mention to them that it may not be a good idea. It's obviously not conditionable, but maybe as a management plan thing.
Absolutely. That will be a specific point for consideration in the management plan and for liaison with the building owner. Definitely.
Thank you.
Note's been taken of it as we speak.
Okay. Unless that's brought up anything for our governance officers since they last spoke. Can I just confirm?
Nothing from us. Thank you, Chair.
Thank you so very much. Okay, so we've now reached the end of the meeting. The committee now has all the information needed, and we will retire to make our decision in private session. We will not announce the decision today. Instead, the hearing on this application will be closed and the live broadcast will end. A summary determination will be sent to the parties within 5 working days of today's hearing. The full decision will follow as soon as possible.